Hello, everyone, and welcome to today's webinar, Why Most Estate Plans Fail. My name is Jennifer Howard, and I'll be your moderator for today. I'm the Marketing Director for Cunningham Legal, and I'm excited to be hosting today's webinar. I'm pleased to introduce our speaker, Ed Goodson. Ed is the Managing Attorney at Cunningham Legal, and we're an estate planning and trust administration law firm with 9 offices around California. Ed is a certified specialist in estate planning, trust, and probate law. Today, he's going to share the 3 stages of estate planning and how each plan is tailored depending on your own unique situation. Before I hand the mic over to Ed, I have a few housekeeping items to cover about this presentation and the Zoom platform. First of all, hopefully all of you can hear us. There's a chat icon on your screen. Please just send us a message from that area if you're having problems. We would love to hear from you during today's presentation. Keep in mind all attendees will be muted, but if you have a question for Ed, please feel free to send it through the Q&A icon at any time during the presentation. Ed will be answering most of your questions at the end. And if we don't get to your question during today's webinar, we'll be sure to follow up with you afterwards. A few polls will be conducted during the presentation, and your participation is greatly appreciated. When I launch a polling question, a window will pop up on your screen. Simply select your answer and it will automatically be registered. And lastly, today's webinar will be available on demand after the live session, and we will send you an email with the link within 48 to 72 hours. So without further ado, I'd like to kick things off by welcoming Ed Goodson. Ed, over to you.
Thank you very much, Jennifer. Hello, everyone. My name is Ed Goodson. I'm the Managing Attorney at Cunningham Legal. We're an estate planning and trust administration law firm located in California. We have, as Jennifer mentioned, we have locations. We have 8 attorneys and we have 9 offices throughout California. You can visit our website to see which cities we have offices in. We also do conduct meetings with prospective clients via video conference. So if you aren't located near one of our offices, we can still work with you.
Today's agenda.
Yeah. Oh, today's agenda. The 3 stages, today's we're going to talk about the 3 stages of estate planning, how estate plans are tailored depending on your unique situation, how to get started in estate planning, and then we'll have your questions and answers. Okay, so now before really getting going, I need to put this legal disclaimer up here. I want to emphasize to everyone that what you're going to hear today is legal information. It's just for informational purposes. This is not legal advice. Legal advice is when you talk to us one-on-one, talk to one of our attorneys, and we apply the facts of your situation to the law that's applicable in California. So this is not legal advice. Don't go out and do something rash based on what we talk about today. But I hope that you'll find this interesting and helpful. With that being said, let's begin. This is a lot of info on this slide, but it shows you the 3 stages of the estate planning process. Most people think it's only about the documents in the first column, that estate planning is about getting your documents and then you're set. It definitely begins with documents, but our approach is different. We work with you during each of the 3 phases. The first step is certainly the documents, and we'll be talking about that. But what happens when your plan is done? Think of the example of a cell phone from the 80s. Would you think that phone would even work today? It'd probably be as big as a brick, actually. It wouldn't work at all. And it's kind of the same as with your estate plan. Your estate plan, if you got it in the 80s or even just 20 years ago, it's probably not going to work anymore. So you really need to keep up to date on your estate plan the same way that you would with a cell phone. Now, you also have to plan not only for death, but you have to plan for incapacity. Some people, they say, well, you know, once I pass away or become incapacitated, what do I care? I'm not going to understand what's going on. I'm not going to be there. But, you know, really, I think that you ought to consider how you'll be remembered by your loved ones. And if you've ever been in the position of taking care of an estate of someone who's incapacitated or who has died, you'll know that doing this kind of planning and doing it thoroughly is really worth your time and effort. So we're going to go on to meet a couple of families. The first family is Doris and Chris and their kids. And their concerns are that first, they don't have a living trust. They own a home, but they think that maybe they need a living trust. And they have a special needs child. And they also have minor children, and no one is set up as a guardian yet if something happens. So let's talk about why they need a living trust. They need a living trust to avoid probate. Let's talk. Probate is bad. You've probably heard how bad probate is. I'm going to give you some examples. Probate in California cannot be completed in less than 9 months. It's impossible. The average is 16 months. It depends on the county. It's a totally public process, and it's very onerous and it's costly. Typically I've seen estates having to pay more than 4% of the total estate towards probate costs. Sometimes it can be as much as 50%. It can be very, very bad. That's what happens when somebody dies who has real estate and they don't have a living trust. But a living trust also helps people avoid conservatorship. And conservatorship is kind of difficult to explain, but what it is it's in the probate court, and it's when a person who is incapacitated needs to be cared for, but they didn't do any estate planning. So the court has to appoint somebody. And first you have to have an incompetency hearing, and then it just gets worse from there. I like to refer to it as probate on steroids. Everything that you don't like about probate is worse than conservatorship, and it can last for many years until somebody passes away. So certainly something to be avoided. And again, a living trust plan can help avoid that. Guardianship, on the other hand, that's taking care of the kids. That's about taking care of the kids. So if both Doris and Chris died, who would take care of the kids? Well, we hope it's the guardians that Doris and Chris name in a document. However, that's just a suggestion to the courts. So would a will be enough for this family for the estate planning? Not at all. They need much more than that. First, they need the living trust and the wills. Living trust is most of their assets are going to be put in the living trust. Some assets can't be put in the living trust. And in California, those assets that aren't in the living trust, those are retirement plans, some annuities, and firearms. They can't be in the living trust. Everything else should be in the living trust. And the living trust helps on management of all the trust assets during incapacity and upon the death of Chris and Doris. The next document they need is a power of attorney. And a power of attorney applies to non-trust assets when Chris and or Doris are incapacitated. So it's about managing non-trust assets during incapacity. The healthcare documents are used so their loved ones can make medical decisions for them during incapacity. Guardianship nomination, I talked about it. Oh, I'm sorry, living will, don't want to skip that. Living will is a document where they get to say whether they want, if all hope is lost, whether they want their loved ones to be able to pull the plug. Very important to have that. We talked a moment ago about the guardian nomination, and it's funny, is guardian nominations don't have to have many formalities. They just need to say what you have in mind. You know, who takes care of the kids, who steps in as a parent if we're not there to take care of them. The judge doesn't have to appoint the people you appoint. So it might be a good idea on your guardian nomination to say why you've chosen those people to help them out. Most of the time, the courts don't have any idea who the parents would have wanted, and so it's fantastic to have a guardianship nomination for them to look at. And finally, let's talk about a special needs trust, because we said that they have a special needs child. A special needs trust is designed to help the recipient, the child, receive they get to receive their inheritance, but it doesn't knock them off of government benefits like SSI. So the inheritance is used for things that the government won't pay for, such as food, shelter, and clothing. Very, very valuable thing. Anybody who has a special needs child should seriously consider getting a special needs trust.
Okay, everyone, we're about to launch our first poll question. The question is, if you have a living trust or estate plan, how many years has it been since you last reviewed it? The responses are within the last 5 years, within the last 5 to 10 years, 10 years or more, or I don't have a plan. Please take the next 15 seconds to make your selection, and then we will share the results. Okay, it looks like most of you have responded. Those of you who have not yet responded, go ahead and submit your responses now, and we'll close the poll in a few moments. Okay, we're going to close the poll, and it looks like a majority of you said, I don't have a plan. Very interesting, Ed. Okay, I'm going to kick that back off to you.
That is very interesting. Well, people do need to have a plan. We'll talk about how important that is in a moment. So as we move on, we're going to meet the next family, Ernesto and Lucy. This is a married couple with an outdated trust. Their estate plan is 10 years old. They just purchased a vacation home, which is not in the trust's name. And interestingly, they have 2 children with very different needs. Their son, Martin, he's wealthy and owns his own business. So that sounds great. And their daughter, Maria, has creditor issues, and she also has marriage problems. So are there things that Ernesto and Lucy that we should be thinking about when we do the planning with Ernesto and Lucy that we might not think about with other people? I think that there really are. First, we're going to talk about tax planning. When we're doing estate planning with Ernesto and Lucy, we're going to be thinking about estate taxes, generation skipping transfer taxes, gift taxes, real property taxes, capital gains taxes, and income taxes. That's a lot of taxes. I'm just going to highlight a couple of big things that we want to consider. If Ernesto and Lucy have had their house for a long time, their house may be protected under Proposition 13. In other words, they're paying a very low, they have a low assessment value on their house, so they're paying low tax rate. And if either of their kids want to keep the house after they die, the kids would want to have that same low tax rate. If we know that, we can write the plan so that that would happen, and that could be very valuable to them indeed. The next issue that we worry about with taxes is reducing capital gains taxes. They have this same house, and many of their other assets may have increased in value over time. If so, if they liquidate them, they're going to have to pay capital gains taxes. Well, the good news is, and we'll get to tell them that, since California is a community property state, and since the assets they own are probably community property, that if either of them dies, then all those capital gains taxes go away. It's kind of automagic. It's a great thing in the tax law. So a lot of people don't realize that with their assets that have gone up quite a bit in value, that it's a bad plan to give those assets to their children during their lifetime, because it won't get that step-up basis at their deaths, and won't make the capital gains taxes go away if they give it away. Also, if they sell it, they'll just have to pay the taxes. So keep your appreciation. Many people need to keep their appreciated assets until they die. And then finally, I'm going to talk a little bit about estate taxes. Right now, the estate tax exemption, the federal estate tax exemption, is $11 million plus per person. So a couple who has $22 million estate probably is not going to have to pay any estate taxes. However, in the recent past, it was as low as $1 million. That was the exemption. And so frequently on older trusts from before 2014 especially, they had AB trusts. It was a mandatory split. At the death of one of the spouses, the trust would have to be split in half. And this saved a lot on death taxes. It was a great plan. However, now it is no longer necessary, and it has a lot of downsides, and it's very costly in capital gains taxes first, but it also causes great confusion to families, and it's really something that we need to avoid in most cases. So, if you have a trust that was last reviewed prior to 2014, you really need to see an attorney to check that out.
So, Ed, we have a question from Francis, who is asking, how do I know if I have an AB trust?
It's really hard. It's really hard to tell whether you have an AB trust. In fact, sometimes for us attorneys, it's hard to tell. Essentially what the trust language says is, upon the death of one of the spouses, then the trust has to be divided into two portions. You'd think that that would be clear in the trust language, yet a lot of times it's not. A lot of times it says it shall be split unless the trustee doesn't want to, or which sounds like it's an oxymoron. There are a lot of ambiguities. To figure this out, you really need to see a good estate and trust attorney to figure this out. Let's go on to what we can do for Martin. Now, I mentioned about their son, Martin. He owns a business. He's doing well financially, but they certainly want to take care of him as much as they can with the assets they're leaving him. And for them, we would recommend an inheritance protection trust. So what'll happen is upon his parents' death, instead of Martin just receiving his assets outright, his inheritance outright, it's going to remain in a trust for him, and he'll have management and control over that trust if he wants to, and he'll have access to his inheritance if he wants to. But it could be that he consults with tax advisors, he consults with good estate and trust attorneys, and he figures out, you know what, I would be better off not having management, maybe not having as much control, because by taking away that management and control, we can protect those assets from his creditors if he has any. And if he's somebody who runs a business, he might have high fear of being sued by creditors, predators, and of course, we always have to worry about the possibility that he might get divorced. And a lot of times, inheritance get eaten up by divorces. So an inheritance protection trust is the right thing for Martin. Now, Martin's sister Maria, she hasn't done as well financially. She doesn't control assets very well, and she also has marital problems. And as I mentioned before, divorce is really very hard on inheritances. So for her, what we're going to recommend is a dole-it-out trust. Again, it's a continuing trust for Maria, just like her brother got, except in this case, Maria doesn't personally have the option of controlling or managing the assets. Somebody else will have to manage it. Maybe it's her brother. Maybe it's somebody else who the clients or her parents have suggested for her. The result is she's guaranteed to get her inheritance. I know it may seem to Maria like, oh my gosh, they've disinherited me, but actually she's going to end up getting a much bigger inheritance through this kind of planning than she would if we just gave her the money outright at her parents' death, and then unfortunately it might be squandered. So what are the proper planning methods for Ernesto and Lucy? We've talked about how to take care of their kids. What we do is we create a living trust for them. We do a restatement. They already had a living trust. It's 10 years old. They already have their residence in that living trust. What we do is we keep the name of the trust and we change all the words. We restate all the words. It's amendment in full of the trust. It saves money. It saves hassle. And then we make sure that everything they own goes into the trust. That vacation home that they just bought, they need to get that into the trust. And so we're going to deed that into the trust for them. And then we're also going to create a new plan that's unique for their loved ones. What I was talking about for Maria and Martin, those continuing trusts that are going to help them so much after their parents die. All right, the last person we're going to talk about is Rosie. Now, Rosie's health is starting to decline. She's showing early signs of dementia, and she's concerned that she doesn't have proper planning. Her children live out of state, and the family needs a game plan of how to handle incapacity. She also has a large IRA, and her husband was a veteran. So let's talk about some of the issues that come up for Rosie. The first one that she cares about the most is long-term care. So the question I want to ask all of you is, are you prepared for long-term care? Let's see. If you had to pay for long-term care, How would you do that? Would you pay out of pocket? Do you have enough money to pay for long-term care? Think about nursing home care. Do you have long-term care insurance? That would probably be good if you had it, but most people don't have it. You could get a reimbursed mortgage on your home. Those are pretty expensive, and as a result, your kids may never get your home. You might, like Rosie, you might plan for Medi-Cal and veterans benefits. Since her husband is a veteran, or was a veteran before he passed, she is also eligible for some long-term care benefits from the Veterans Administration. And anybody whose estate looks the right way, who they can have a house, but they have very little in cash, anybody can be eligible for Medi-Cal to help them. So let's talk about how much it costs for a month in nursing home in California. I'd like everybody to imagine in their mind, what's it cost for a month in California? Guess a number, and let's see how you did. According to the state of California, this is the average right now, $9,337 per month. And if you happen to live in one of the more expensive coastal cities, it's going to be more expensive than that. Also, it's more expensive than that for some people, depending on what kind of ailments they have. Some people, for example, we know who have both COPD and dementia. Well, they need to make sure that they are watched all the time. Otherwise, the COPD treatment can't be done properly. And as a result, people in those kind of situations might be more like $30,000 a month. So preparing for the cost of long-term care is very, very important. And that's what we need to do for Rosie. One of the reasons it's very important is that so many of us will face disability in our lifetime. A lot of people don't realize this, is 70 to 80% of us in the United States will face disability in our lifetime. And that's almost a certainty. Just imagine if you could get lottery odds in your favor that were that high. I mean, you'd be planning for that. So anyway, the things that you need are the documents that I talked about before, the durable power of attorney, the medical documents, living will. You also need something called a post form. This is something that you don't get from your attorney, you get from your doctor. It stands for Physician's Order for Life-Sustaining Treatment, and it has largely replaced the Do Not Resuscitate, or DNR form, in most states. The post form is bright pink, it's one sheet, it's got writing on both sides, and so you may have seen these around. When I've heard that when the firefighters or EMTs come into a house or are at the scene of an accident, they look for this document. They look for that bright pink sheet. And if you have a Do Not Resuscitate order, on the sheet, it would be signed, the order would be signed by the physician. And the emergency medical people are going to follow the physician's order, and they will do exactly what the order says. Some of you who, especially if you're younger, may be wondering, well, why is that even necessary? As it turns out, many people who are over 75 or 80 years old, when they go through CPR, it breaks their ribs. So it may save them at the moment, but then doom them to 3 more months of living under extreme pain, and then they end up dying from the injuries anyway. So for a lot of people, they need to talk to their doctors about whether they wanted to be resuscitated, and the post form is the document to use. And you need to keep these documents up to date. So what about that IRA? How do we deal with that? Well, there are a couple of things to think about with the IRA. With respect to long-term planning, the IRA or a 401k doesn't really get in the way of Rosie being able to receive Medi-Cal or VA planning. It's considered an income stream. The money that comes out to her is an income stream. It's not really considered an asset to count against her in most situations. So the IRA, we don't have to do much with it to plan for her lifetime. But we do need to consider, what about her kids? Remember, she has some kids who live out of state. She wants to leave that IRA to them if there's anything left. And for many people, what they do is they just name the kids on the beneficiary designation form, and they believe that that's going to work. And what happens is that does not get the best tax benefit. Under the current law, if you leave an IRA to somebody who's, say, 10 years old, and it's worth $100,000, it'll be worth millions over their lifetime. Now, right now, we have the Secure Act, something that they're looking at in Congress. They're looking at changing the law, and it's not going to be nearly as generous. But it's still the same. The same thing applies. Is you'll want to stretch this out. You'll want to stretch out the IRA over time. And to do that, the best way is to have a special trust created called an IRA Legacy Trust, where after Rosie dies, instead of giving the assets directly to the kids, it goes into this trust, and the trustee of the trust makes sure that the assets get stretched out over time as best they can. Under the current law, that would have a big tax benefit and would also protect that IRA from the kids' creditors, predators, and divorce. Under the future law, which it looks like Congress is really thinking about passing, the tax benefit is not going to be as big, but it's still going to be very big. And you still have that issue of keeping the IRA safe from creditors, predators, and divorce. Definitely worthwhile, definitely worth doing. So what are the proper planning steps for Rosie? We set up a plan to take care of her. We make sure that the plan prepares for incapacity and especially Medi-Cal and VA benefits if she needs it. And we also set up an IRA trust to protect her IRA for her kids.
Okay, so it's time for our next poll question. And the question is, if you have a living trust or estate plan, have you ever reviewed the asset alignment with your attorney? The response options are yes, no, or I'm not sure. Please take the next 10 to 15 seconds to make your selection, and then we will share the results. Okay, it looks like most of you have responded. Those of you who haven't yet responded, just go ahead and submit your responses now. And okay, perfect. We're going to close the poll, and it looks like most of you said no. Very interesting. Ed is going to talk about that right now.
All right, well, let's talk about why we asked that question. There we go. So here's why we asked that question. On the left column, we've already talked about the documents that were needed. So imagine all those three different families that we talked about. So we've got all the documents in place. Well, what happens is that's the first stage. And the last stage, incapacity and death, that is kind of obvious, right? That's why you do the estate planning, is so that the documents are there to help you and your family upon incapacity and death. Strangely enough, there are a lot of law firms and a lot of lawyers who help with the estate planning, but who never do the helping of the family at incapacity and death. And I think that's really a mistake. You know, the way I look at this is kind of like a chef who doesn't eat his own cooking. Okay, it's how are you going to know how good a cook you are if you're not tasting it later? With estate planning, it's kind of like that. The documents that are prepared need to be prepared by people and by law firms who are experienced in helping at incapacity and death. And our firm definitely is that way, as I'll talk about later, as we have a lot of people who are working all the time with families helping at incapacity and death. Now, the middle stage is what we say is everything in between. This is the stage that very, very few attorneys look at and care about at all. And it's our experience is this is why estate plans fail. Is they can fail because people didn't do any planning or the planning wasn't done very well. But the big reason they fail is because the estate plan is outdated by the time somebody becomes incapacitated. So the estate plan is outdated by the time somebody dies. Well, we have to wonder about that is how would you avoid that situation? I mean, well, the best way to do it is to review the estate plan in a thorough way every year. We don't know when you're going to die. And so if we review it every year, we will have a recent reviewing of the estate plans. But we don't just review the estate plan, because it could be that every year we look at the documents and your plan was great and it still applies to you and we don't have to make any changes. Then really importantly, we look at asset alignment. Now, in our case studies, the most obvious example of an asset alignment problem was that we had a couple who had recently purchased a home, a vacation home, and it wasn't in the trust yet. Well, they had perfectly good documents, but that asset, had they left it like that, would have gone through probate, and probably might have cost them $20,000 to $40,000, cost their family and a lot of hassle. So what we need to do is every year meet with our clients and find out, is everything up to date? Not just the plan, but are the assets aligned with the plan? And in the case of that home, the alignment was that it needed to be titled the same way. It titled into the trust. With respect to Rosie's IRA, it needed to have a beneficiary designation form, naming the IRA trust as the beneficiary. So that's what we're talking about as alignment, and alignment is key in avoiding failure of an estate plan. In order to make sure that the estate plans we create don't fail, we offer this legacy care program. And our legacy care program is exactly what I was talking about. It's an annual review, not just of your estate plan and your estate planning documents, but of your assets to make sure that they are properly aligned with that plan. So we verify that they're aligned, and we track all the assets. And this way, we know for certain that your loved ones will be taken care of now and in the future. This avoids the most common problem for failure that we see in estate planning. I don't know how many of you have ever been involved in administering a loved one's estate. It's really hard, okay? It can be really, really overwhelming. It's very time consuming. It's a lot like having another job. In fact, I have a client who just last week was mentioning to me that he wasn't expecting to go back to work full time. And essentially what happened is he's acting as trustee for an old friend who she didn't have any children, and he was a close friend. And so here he is 4 or 5 years into retirement, and all of a sudden he finds himself working about 30 hours a week on her trust. And she had a very well done estate plan. It's just a lot of work. It's also a personal liability. He was really surprised to find out when I told him that, you know, if he doesn't get the assets to all of the right people, and she had a long list of the right people, as it turned out. So if he doesn't get the assets to the right people, then he's personally liable. They can come after him. Similarly, if she had any debts, he would need to make sure that those debts are taken care of from the estate, or he could become personally liable. And the worst thing is that if she's behind on her taxes and he hasn't figured it out, the IRS is not going to come after the trust. They're going to come after him personally. So being a trustee is hard. There's a lot of personal liability. It's a lot of work, and it can be totally overwhelming. And what you really need to do if you're ever a trustee is work with an attorney to ensure that your loved one's affairs are handled without mistakes. You want all the court and government mandated deadlines to be met, and you do not want to have to deal with probate. So, and that's really what we're here for. We have a trust administration department, and what we do is we help families once one of their loved ones has died or become incapacitated. That really makes our firm turnkey. We help on the estate planning portion. We help on the annual reviews to make sure that all the assets are aligned and make sure that that estate plan is going to work. And then after you become incapacitated or die, we take care of your family and make sure that this goes as smoothly as possible for everyone.
Okay, it's time for our last poll question. And the question is, on a scale of 1 to 5, how ready are you to create or update your living trust or estate plan? The responses are 1, do not want or need to update my plan, 2, not ready, 3, still not sure if I'm ready, 4, somewhat ready, or 5, ready now. Please take the next 15 seconds or so to make your selection, and then we'll share the results. Okay, it looks like most of you have responded. We're going to close the poll in a few moments. Okay, great. It looks like a lot of you are ready now. That's good. And you know, it's okay to still not be sure, but That's some great info. Okay, so before we move on to our Q&A, I wanted to mention that as attendees of this webinar, you will qualify for a free phone consultation with one of our attorneys. Please reach out to us at team@cunninghamlegal.com or give us a call at 855-250-9988 to schedule or for general questions. Okay, with that, we're now going to answer some of your questions submitted during today's presentation. As a reminder, you can still submit questions through the questions pane in your attendee control panel or through the chat icon. Okay, Ed, our first question is from Samantha, and she is asking, I am a single mom with a special needs child. What happens if I don't appoint a guardian for my child?
Wow, that so remember that I mean, I'm thinking about all the. First, you need to have a guardianship nomination there, and it's also potentially a nomination for conservatorship for once the child becomes an adult. It's very important to have that because once the child becomes an adult, or if the single mom has something happen to her and the child is on his own, the court needs to know what you wanted. And that nomination form is going to allow that to happen. You definitely have to have something in writing for that. Otherwise, the court doesn't have a clue. If there is any estate to leave to the child, there should also be a special needs trust, because otherwise that estate will essentially be very costly. It'll knock the child off of government benefits for a while. But a guardianship nomination is really important for any minor child, and is especially important for anybody who has special needs.
Okay, great. So Jane is asking, my husband just lost his parents and still he's not convinced we need an estate plan. How can I help change his mind? Sorry, Jane, I just messed up your question, but I think, Ed, you have the gist of it.
Right. We see this a lot. I wanted to mention, I saw this in my family a lot. My grandfather was from Texas, and my grandmother used to every once in a while try to corner him when everybody was there for Thanksgiving and say, hey, Lee, don't you think we ought to be buried back in Montrose, Colorado, where we came from? And he said, I'm against it. She said, what do you mean you're against it? He said, I'm against dying. So he was very much against any kind of planning. And as it turns out, that, he was buried where she wanted him to be buried, but there was still a lot of hassles as a result of him not wanting to plan. I think that what gets people to really convinced that they need to get involved in estate planning is to start talking to their friends and just ask a few of your friends, how did things go when somebody in your family died? And you find out that in a large number of cases, they were just terrible. Everything was just a nightmare. And then when people did the planning, the people said, oh, well, everything went fine. It wasn't that big of a deal. And so I think that hopefully over time that he'll come around. But some people, like my grandpa, unfortunately never came around.
Okay, so Pat is asking, if my ex is still on my IRA beneficiary and I pass away, would she still get the funds if we are no longer married?
Okay, so we said X, so it sounds like that they're no longer married. This is really tough. This is one of those questions where you have to come see an attorney about this, because it all depends on exactly how the judgment of dissolution or the marital settlement agreement in the dissolution was written. So I can't even guess. It could easily go either way. Definitely need to see an expert, see an attorney about that. We'd be glad to help you.
Okay, so Carmen is asking, what is the difference between an estate plan and a living trust?
Okay, good question. So when we talk about estate planning, we talk generally about all the things you have to worry about upon death and upon incapacity. One of the living trust is just one of the tools. There are many, many tools, but a living trust is the kind of the basic tool now. Starting, I think that started probably around in the 1970s and 80s in California. More and more people are using the trust as the basic tool. But there are many other tools of estate planning, and those include beneficiary designation forms and joint tenancy and other things. We apply all of those in our estate plans.
Okay, Sarah is asking, my husband and I only see each other at the dinner table and afterwards. We don't have time to visit an attorney during the day. What can I do?
Well, the nice thing that we have going at Cunningham Legal is that we offer consultations with attorneys by phone and even better by video conference, including in the evening. So there are some attorneys like me who my kids are in college, so they've moved out of the house, and if the only time you have to meet with me is in the evening or even on a weekend, we can schedule that. We can work around your schedule. And we like using video conferencing. We typically use the Zoom platform, but we can use others. And we found that it's almost as good as being there. And it's a whole lot better than not doing any estate planning at all. I think, and by the way, this is one of the reasons that a lot of people don't do their estate planning is they just can't get to an attorney's office during the work week.
Okay, so we have an anonymous attendee is asking, and it's a good one. Sadly, we don't trust any immediate family members to properly handle our estate. What happens if close friends that may be candidates move away?
Well, that's a great question. Okay, so there are, I'm going to give you 3 different groups of potential trustees or fiduciaries. So I'm talking about people who can take care of your assets for you upon incapacity or death. One is friends and family. The next one is trust companies. Now, trust companies are really good for managing brokerage accounts and cash over the long period, a long term. I was recently involved in a trust that was set up in 1936, and it was still open 2 years ago. So the next thing that probably this person needs to look into, though, is private professional fiduciaries. These are people who are licensed with the state of California to act as trustees and executors and agents for healthcare. They're licensed by the state to do that. This is what they do for a living. They generally do a very good job. We as attorneys, we know a lot of them. We can recommend some very good ones who we've worked with in the past. So I think that private professional fiduciaries are the way to go here.
Okay, Nick is asking, should I buy long-term care insurance?
Yes, long-term care insurance, generally, yes. I've heard that that even very wealthy people have long-term care insurance, but let me make sure that I'm clear that this is the new form of long-term care insurance that I'm recommending, not the old form. So the old way was that it was a lot like term life insurance. You pay every month, and then if you became incapacitated that month, then the policy would kick in. Okay. Well, what happened is that became very expensive for the insurance companies. The premiums went skyrocketing. Many of the companies stopped doing business in California and in most states. So those are almost not even available now. What we have instead is something that's great, and it's brand new. Maybe 4 or 5 companies nationwide that offer this. You buy a life insurance policy, and let's just say that you paid $50,000 for a life insurance policy that's going to pay $200,000 upon your death. Well, you can get what's called a long-term care rider. It costs almost nothing. Okay, it's very, very inexpensive, and it makes the deal a little bit different. It's the company says, we'll pay you the $200,000 when you die, but if you happen to have long-term care expenses before you die, we'll pay up to that $200,000 on your long-term care insurance or on your long-term care expenses. So the basic idea is they're going to be paying $200,000 one way or the other. And when you have this long-term care rider, they are happy to help you out with the long-term care expenses. And then they just won't pay your family as much as far as a death benefit. This is the way to go. It's really, really a great way to go.
Okay, so we do have some more questions, and unfortunately we are near the end of the webinar. So what we'll do is we'll reach out to anyone who has asked a question, and we haven't had a chance to answer it. But thank you, Ed, and thank you everyone for attending today's webinar, Why Most Estate Plans Fail. If you have any other questions, like I said, please email us at team@CunninghamLegal.com. You will receive a follow-up email within 72 hours with a link to view a recording of today's webinar. And just a note, our office is open until 5 p.m. this evening for those who have immediate questions or want to sign up for a free consultation. And our normal business hours are 8 to 5 p.m. Pacific time. On behalf of Cunningham Legal, thank you for joining us today.
Thank you.